So I open the third session of today, the first of the afternoon. And the first presentation of today's session is going to be the presentation of Tatiana Machalova and Martin Bukovič, which will be performed by Martin Bukovič himself. And the topic of the presentation is affirmative action as a means to achieve equality, a critique of theoretical approaches defending affirmative action. So, Martin, the floor is yours.
So once again, thank you very much, and thank you for the possibility of being here again. I chose this topic because I'm in my dissertation dealing with the problem, like with the interpretation of the futures of discriminatory futures in interpretation of Czech courts. And this topic is certainly connected with that topic when I want to critically analyze this, some theories that defending affirmative action as a tool to reach or to achieve the equality. So, because although affirmative action may be well-intentioned, it cannot often be considered as an effective solution for resulting inequalities. I will show later in the presentation. First of all, I just want to say something about the content, and first I will talk something about, I will introduce the topic, why is affirmative actions necessary. Then I will show it in the exactly case of the Court of Justice, in the exactly case when the Court of Justice confirmed the affirmative action as one of the tool to achieve the equality. Then I will introduce some historical basis, some origins, and theories which I will criticize. Then I apply the criticism also on the specific case. So then I will conclude it. Why is affirmative action merely a hidden form of new discrimination? So first of all, I need to say that we live in the modern democratic state, which is based on the protection of equality. But we still face the discrimination, still is we are fighting against discrimination, still is consistent in our society. So it's need to pay closer attention to the fact that the legal rules are defined according to formal equality. It still may have a disadvantageous impact for some social groups. So the main task for the lawmakers is the balancing the formal equality with the substantive material equality. And one of the tools they use, it's as I said, affirmative action. It's the suitable tool for overcoming the discrimination in these cases. So if I define that affirmative action, what it really means, that's like a preferential treatment for some groups, society groups, which in the past or structurally was suffering by some discriminatory grounds. So, for example, women or ethnic groups. I will show it on the exact case. As I said, that's the aim of the paper, like the critical analyze some traits that they representing that. So, as I show it in the concrete case of the Court of Justice of the European Union. So I've chose this case when a male employee of the Dutch Minister of Agriculture, he wanted to place his child to some type of program that provides the Minister of Agriculture. That program is like specific that the employees for the Minister of Agriculture can place their child to childcare program there, and it was primarily focused on the women. So it was not exclusively, there were some exemptions from that, but primarily force on women. And Mr. Lommers, he fought, or he also argued that he is discriminated based on gender, because it's primarily focused on women, not men. So the Ministry of Agriculture in this case arguments were that the policy that affirmative action here, the measures, are to promote the employment of women in work, like they should have the same possibilities, opportunities to for women and for men to women maintain their work and not to leave to maternity leaves, and that's why they took this measure into this policy, under this policy. So, Court of Justice told that this seemingly like discrimination, but the court applied the test of discrimination, and yeah, it looks like a discrimination, but it was justified by the test of the discrimination, by the equality treatment. It's like a pursued legitimate aim, and measures were proportionate to follow to reach this aim. So the legitimate aim was same as the ministry was talking about, like the provide for women the same opportunities, like not to leave the workplace, and they can follow their careers and continue in it, not to like lose their job because of the maternity. And the measures like that program that help women to place their children into the kindergartens, that was proportionate, because it was not automatically that all women, that it's accessible for all women, because there was limited number of the places there, and there was some exceptions also for the men. In some cases, it depends on the employer, who can decide that in some cases men can join the program. So by the court, that the court told that this in this case the affirmative action are with the principle of equality, like the equal treatment. So when we talk more about affirmative action, like from some origin or some historical view, it's got some symbolic function of recognition of the past form of discrimination. It was developed by the civil rights movement in the 60s in the USA. First, it was mentioned in 61 by JFK, and it's needed to say that the process of evolution of the affirmative action was quite different in the US and in the European Union. In the US, it was more like equality of outcomes. It's a good case of the steel workers versus Weber, where the Supreme Court of the United States confirmed affirmative action, in example of African American, like a real tool of the reaching the equality. So there was like different view in the European Union, where this is more like some specific programs, scholarship programs. It was more viewed like the equality of opportunities. So nowadays, but it was developing, and we can see, as in the case I showed you before, that we can talk also in the European Union sphere, like a measure which follows more the equality of outcomes, like the quota regulation. So one nice view is that the Directive of European Union, which says that some percentage of number of women need to be in the leading position in business companies. So now we can see more like the quotas. So if we look at the theories supporting affirmative action, I first mentioned the utilitarian theory, which also the proponents of implementing affirmative action like always arguing that's argument of them, that they are telling that it's inefficient or it's unfair that some social groups are determining by that cannot reach some position that's not good for the overall happiness, and it outweighs the disappointment of individuals. So as I was talking, the quotas there, which was in the directive of European Union, so it was like forcing to bring more effective, creative, and greater value society, and the short-term negative impacts on men brings that affirmative action are outweighed by long-term benefits of overall equality and outcomes in society. So that's one view, one theory that are for affirmative action as a tool to achieve the equality. The second I chose is the communitarianism. Especially according to Michael Walzer, which is a significant representative of communitarianism, and it gives important framework for discussing justice and affirmative action. That we need to understand the justice in not like a universal principle, but we need to understand in context of various spheres of lives. We can say that what is in one sphere where concrete rules and concrete norms are based. So what is in one rule just, in another cannot be just. It can be unjust. So for example, in the sphere of education, it's just that we can bring some affirmative action to help some social groups to achieve some benefits, some advantages. But in another, for example, the sphere of the market, of the business market, there is the fair, strict rules of fair competition. So there is not good for that for just to bring there some affirmative actions. So if we look at more to the criticism of these theories, so the utilitarianism theory, it's not for it's not bad, it's not good for that it's overlooking the individual rights and interests. So by Nozick, that he argues that the social welfare can be justification for violating individual rights, even for the greater good. This one point of the view that overall happiness is like aimed, that is aimed of the affirmative, even it may disadvantage some individuals. And if you look more to critic of the Walzer's theory, it's like we can say that inequalities may be justified based on the cultural specifics of the communities, but this relativism of this justice principle undermines universal principle of justice, and it may cause that certain groups remain marginalized in favor of others. That means that makes specific privileged groups. If I showed it on the case, like there's the case of the women, which were preferred among the men, and the main point of the working theories who is standing like against affirmative action is that we can see on the case there's equal treatment, but not treat as equal. So the problem, if we apply it on the Court of Justice case, that the people there, the employee, were just, it was focused on the gender, like that was the criterion of the distinction. But we need to focus on the on that employees, not based on the gender, but based that they're both like male and female workers, they are in their parental role. So this we stigmatized men in their role as a parents. So it's as I say, it's like we need to take that men are there not treated as equals. Like everyone needs to be treated as equal, not even male or female. And that's the point of this Dworkin's theory. So that's creating the new inequalities. So if I show it like this, there is some strength of stereotypization of the women in their primary role of the child care positions, and it can cause more discrimination, like they will not understand, they need to have some measures, some policies to achieve some programs. So it may cause the some discrimination impact between these groups. So my question is, like, is a really effective measure if we are set the affirmative action? Is this really effective measure how to have the equality in the workplace? Is it better not based it on the gender, based it on their role as a parent? And that's that working thinking of it. So even if the Court of Justice this way he accepted that's equal treatment, factually it makes new inequality based on that we don't understand as like a parents. So to conclude that, I need to say that's a very big problem of that. It makes new like stigmatization and I said problems in workplace, and it's up to lawmakers to take in advance, so that we need to make some conditions which will take role to treat everybody as equals, not treat equal inequalities. Like so we need to focus on that Dworkin's principle. That's all. Thank you.
Thank you so much, Martin, for your very concise and informative presentation. I'm sure we're going to have interesting questions. And as you have seen, we have started in this panel on justice in practice, discussing some questions of substantive justice, so going beyond the formal justice, substantive equality, going beyond formal equality. And now we're going to extend even more that justiceness by actually taking a look which is recentering human rights towards the wider system within which we live, the ecosystem. So from homocentric to ecocentric understanding of justice. And in that sense, I would like to give the floor to Šejla Imamović, whose presentation is entitled Justiciability of Environmental Post-KlimaSeniorinnen Claims. The floor is yours.
Okay, well, good afternoon, everyone. And before I start with my presentation, I would just like to thank the organizers for having me here in Belgrade. It's been really amazing to be here. It's my first time also in the city. So Yeah, I'm very grateful and very happy to be here. So the title of my presentation is Justiciability of Environmental Claims Post-KlimaSeniorinnen, which means that I will talk about the possibility to approach courts with regard to, I say environmental, but specifically climate change claims after the judgment in KlimaSeniorinnen v. Switzerland, which is a judgment that probably most of you, if not all of you, have heard. Maybe some of you have read. And if not, that is okay. It is 260 pages. It's a very lengthy judgment. So I will, as an outline of my presentation today, I will give a brief summary of the judgment. Obviously, I cannot engage in all the different details, but I will try to highlight some of the most important elements that I think came out of the judgment. Then I will mention what the sort of the main issue or critique has been with regard to the judgment, and then what my main argument or my main thought is about this critique. And then after that, I will delve into two specific elements of that judgment, one concerning the legal standing, as was discussed in this judgment, and secondly, the margin of appreciation, which then links more to the substantive part of the judgment, but I will sort of focus on the two concepts and how the court has dealt with those in this case. And then finally, a few thoughts on implications. Note that this judgment is from this year, more precisely 9th of April of this year, so this is sort of first exploration. There is not much out there. Of course, it has been discussed very widely and there are blog posts and things, but in terms of publications, it's really very much explorative. So I also look forward to any comments and suggestions in that regard. So starting with the judgment, but now I have to, okay. Starting with the judgment, the first thing I would like to mention is that KlimaSeniorinnen v. Switzerland case was a part of a trilogy, as it was referenced by the former president of the European Court of Human Rights, Robert Spano, who was involved in the case. And he emphasized that it is important to view this case in light of or together with the other two cases that were decided together with this case. They were not sort of formally linked, but they were addressed by the same Grand Chamber composition and were very much interlinked. Now, even just before I enter into the KlimaSeniorinnen case, I will just mention very briefly what the other two cases were about. And this is brief because they were both declared inadmissible. The one is Careme v. France, and the other is Duarte Agostinho and others v. Portugal and 32 other states. All of the cases dealt with climate change claims and the adverse effect that climate change has on health. What was different is that the applicants were different in these cases. So in KlimaSeniorinnen, as I will come back to, we had senior citizens as individuals, as well as a civil society association claiming the adverse effects on health of senior people in Switzerland. In Careme v. France, we had a former mayor of a town in northern France, all claims concerning, of course, global warming, claiming that the rising of sea levels and so on were very problematic and would to cause adverse effects in the future in that town in France. And in Duarte Agostinho, we had a group of children basically arguing the impact of climate change on future generations. Now, as I mentioned, Careme and Duarte Agostinho were declared inadmissible. And why it's important to start with that, because, and I'll come back to it also at the end of my presentation, is because I think in these cases, the court showed that it had a very strict application of admissibility conditions. So in Careme v. France, the court concluded that there was no victim status in that case because this applicant had left the town that he lived in and became actually a parliamentarian in the European Parliament in Brussels. So therefore, no longer a victim. And in Duarte, Agostinho, and others, the court also declared inadmissible, and in this case, because of non-exhaustion of domestic remedies. The children from Portugal argued before the court that because it was against Portugal and 30 other states, the argument was, well, this is cross-border, trans-border issue, and therefore exhausting domestic remedies really in one state would not work. We need to address it at the European level, and therefore there was no need to exhaust domestic remedies. But the court was very strict in this regard, even though, of course, there was some sort of compassion towards them being children and the whole point of it. Nonetheless, the court concluded that because there were some remedies that could be exhausted at home, they first had to be exhausted, therefore inadmissible. Now, coming to the ClimaSeniorinnen, which was the only successful case, as I mentioned, the case is the judgment is very lengthy. It has different elements, but initially the preliminary considerations, which are very lengthy, where the court tries to illustrate and explain the context in which this decision is made. The court recognizes the complexity of the matter, the factual matter that it has to decide on, namely the adverse effects of climate change, and something that is sort of for the future, which is not something the court normally does. The court is reactive once violations already happen. So the court really did take time to show and explain that it is aware of what kind of judgment it is rendering in this particular case. So it was not only about resolving the legal issue, it was also about deciding on its own role in such cases. And this is what was particularly interesting for me. Now, as I mentioned, there are two: procedural part and the merits part. In the procedural part, of course, again, admissibility, what was really interesting was this part of the victim status, where it was examined for individuals and for the association. And I will come to that later on more in detail, but I can already disclose, and as you might know, the court ultimately found that individuals had no legal standing. They could not be considered victims under the law in the ECHR as it stands. However, the association in question, ClimaSeniorinnen, which consisted of the individual applicants and other senior citizens, was considered to have this legal standing. And this is the revolutionary part of this judgment, the remarkable part, because no one really expected that an association would to get legal standing to litigate in such a case. And then on the merits, of course, many interesting points, not enough time to discuss them all, but I will reflect on the concept of the margin of appreciation and how it was used, because in this particular case, the court again did something that is novel, which was to use margin of appreciation in a kind of split way, meaning that it awarded narrow and wide margin of appreciation at the same time, or reduced and wide at the same time, depending on which element of the case was at stake. And this is interesting because, of course, normally the court either awards narrow or wide margin of appreciation, and certainly in cases as complex as these, concerning very policy matters that are very difficult to determine, the court normally would award wide margin of appreciation. But okay, moving on to the issue. So what was with this judgment? And before delving in, I want to already illustrate what the main critique was, and then also what I think of it, and then I will go back to the legal standing and the margin. Now, the main critique came from, the Swiss parliament, which in the aftermath of the judgment issued a declaration that it will not comply with this judgment because the European Court of Human Rights went beyond the scope of its competences in this case. In the view of the Swiss parliament, there was no scope for the European Court of Human Rights to meddle with what is meant to be done with, democratically elected bodies in this case, in these very complex, scientifically complex matters. So the issue with separation of powers, this is not only from the Swiss parliament, which was, I guess, or one could say logical or to be expected consequence, but also we had a Judge Ake, so we had the UK judge dissenting in this judgment with more or less the same argument. And here is where we see a difference in how judges, even within the court, perceive their own role in such cases and their own in relationship with other branches of government. Now, why this was considered this critique, it came from different corners. The argument was, well, the court is expanding the concept of victim status, which is then, once it was awarded to associations, the court is creating a new right to effective protection from serious adverse effects of climate change. We don't have a right to healthy environment or anything comparable in this case. So this is where in the CleanSeniorinnen, the argument of these senior citizens was relying on Articles 2 and 8, which correspond to the right to life and the right to private family life and home, which then can be linked with climate change because of adverse effects that can have on the enjoyment of course, of the life itself, but also the enjoyment of life in the sense of Article 8. Also for imposing a new positive obligation, this was the argument, to mitigate effects of climate change. So CleanSeniorinnen is a very important judgment in a sense that it is the first judgment where the court sort of brings together and links climate change and human rights. It dealt, of course, with elements before, and there is environmental case law before that, but this was really the very first case. And so the argument goes, this is a new obligation. And then finally, because it reduced the margin of appreciation in such a matter which normally the court would never do when it is so sensitive, also politically sensitive, when it's also so problematic, transboundary, normally the margin is always, even if the case is accepted, which of course the argument of the Swiss government was that it shouldn't be, but even if it is, then at least wide margin should have been awarded. Now, my view of the judgment and my argument is that is sort of twofold. First, I find that judgment is only a first step in climate change litigation. I don't see it as this revolutionary judgment, progressive. I know that some colleagues here would disagree, but that is maybe also due to the fact that I'm an academic. Since I've graduated, I've been in academia. I haven't seen much of the practice, so maybe that is the reason. But I think the court has made certain steps, but I don't see it as a revolutionary judgment where now suddenly climate change litigation has become, there's open door to litigate, and I'll come back to this. In terms of why. And the second part is that sort of more regarding the current ECHR law and doctrine, where I find that the judgment is in accordance with the existing case law and not an act of judicial activism, which is what the court has been accused, even within the dissenting opinion, of doing here. Now, to explain this a bit more, I go back to the two concepts, two aspects I've said I would discuss, namely legal standing and the margin of appreciation. Now, when it comes to legal standing, the court obviously made a distinction between individuals and associations. And as I mentioned before, individuals, the court ultimately held that there was no victim standing. For the victim status or legal standing, for the victim status, the court put two conditions which resemble conditions that it normally has for a victim status in general in ECHR law, but then with this additional tailored approach to climate change. And the court held that, well, in order to have a victim status, there has to be a high intensity exposure to adverse effects of climate change. That is, level and risk of adverse consequences must be significant. This is what the court has said. And then the second part is, of course, then the problematic part. The first part is already problematic. The second is especially problematic, the causal link. There has to be, you need to show as an applicant pressing need to ensure individual protection, so for you personally, owing to the absence and or inadequacy of any reasonable measures to reduce harm from the adverse effects of climate change. And this is exceptionally high threshold. This is what the court has admitted itself in the judgment, and this is also what most commentators agree with. In this case, there were four, as I mentioned, four individual applicants, and they in the end did not get the victim status. Now, when the court moved on then to look at associations, this is where the court found itself in a dilemma, and it expresses this also very nicely in the judgment, because it says, well, if we continue this strict approach, we will have to find that also for associations, if we look also at the previous case law in general, because by the way, I forgot to mention, but the point was always to remove itself from actio popularis, right? That is something that is not allowed in ECHR law. And with climate change, it always sounds a little bit like that you're trying to challenge something that, because it's something that has not happened yet, and it's really hard to prove your individual link with it. So here, the court then found itself in a difficult position, and then it said also in a dilemma. Okay, if we continue this strict approach, associations normally cannot even argue Article 8 claims or Article 2 health reasons. How? What? So if we maintain this, that means that these rights cannot be vindicated. That means that these people will not have access to court at all. If we keep the case law as it is, that is also not an option, because then again they will not qualify. So we need to find a balance. We need to find a way, and that new way was a new criteria for associations, which is low threshold, relatively easy to comply with. It has to be lawfully established in the jurisdiction concerned, so an NGO or a civil society association. It has to be dedicated. It has to have dedicated purpose in accordance with the statutory objectives in defense of human rights, limited to or including collective action. And it has to be genuinely qualified and representative to act on behalf of members or other affected individuals. So these are the new criteria for associations, and this is considered to be so progressive and revolutionary about the ECHR law. And as I mentioned, for me, this still, even if it's new, it still is in accordance with ECHR law. And I'll come back to it. But first, on the margin, which is the second element. For the margin, I mentioned already, the argument was that this reduced margin was inappropriate because we are talking about positive obligations. Normally in ECHR law, if we are talking about positive obligations, it means reduced margin of appreciation, because obviously the convention is about negative obligations. And secondly, we're talking about scientifically complex policy matters, which also means that it is something that the court normally awards wide margin of appreciation. As I mentioned, what the court did in this particular case is to say, well, normally, yes, we would award wide margin of appreciation in such a case, but here we cannot do that. And that is because of that context that the court initially introduced in the preliminary remarks about the urgency of dealing with climate change matters, because there was already international law in place, agreements made in terms of what needs to be done to combat climate change. And there was urgency with this matter. And the court has called it one of the most pressing issue of our time, really, that we need to deal with it right now. So the court said, well, it is reduced when it comes to setting clear objectives to combat climate change. So you have to have clear targets. You have to have, for Switzerland and any other state, if we take, that this case applies more generally, and the court has developed some detailed, has been criticized for that, some detailed rules about how and what, but that is the first part. The second part, in terms of means employed to achieve these objectives, for that the court has said the margin remains wide, so states can still decide how they're going to comply. What matters is that they maintain compliance with their own international obligations according to the Paris Agreement and other EU law, regardless of, depending on which country, other agreements that have been made on the international level. Now, looking at and coming back to my argument, which is that this is not so revolutionary, what I've said so far, and that this would be in accordance with the current ECHR law and doctrine. When it comes to legal standing, this was perceived for associations highly problematic in terms of future victims and violations and representation by associations. But looking at the case law in general, we see the future victims and future violations is not new in ECHR law. We have it, for example, with extradition. So we have seen cases where the court has ruled violations of Articles 2 and 3, for example, in the context of extradition, if a person were to be extradited. Obviously, a different set of case law, but the concept itself of future victims and future violations is not new. When it comes to representations by associations, there too, the court has recognized in the past case law that if the victim is no longer able to represent itself, it can be represented also by someone else or by an association. So this too has been recognized. Admittedly, it has been recognized as long as the individual person would have victim status itself, which is different from this case. But there is something that I will come to now that I think still justifies this approach. And with regard to the margin of appreciation, yes, complex matter, policy matters, scientifically complex policy matters, as well as positive obligations do lead to wide margin of appreciation. But another very important aspect that the court always considers when determining margin is consensus. Sometimes it refers to it as international European consensus, and in this case, it refers as global scientific consensus. And there have been cases of very sensitive policy matters, cases where also requiring positive obligations on the states, where the court, because of the consensus, has found a violation and has imposed duties on states. And here we can think, for example, of case law on giving formal recognition to same-sex couples, for example. That was a positive duty that states had to impose on states, and it also concerned sensitive matters. Yet the court, because of the growing census, not even as vast as it is in climate change situation, the court has awarded it. So I think this stands on its own. However, what I think is the key factor still that helps us understand the court is the element of future generations. And here is where I go back to the other two cases that were there originally and why we have to see them as a whole. The court, when justifying all of this, it's interesting if you look at the judgment, the court keeps referring back to future generations. And here we are not talking about, it was not about intergenerational equity at all, yet the court keeps talking about it. That is because ClimaSeniorinnen was not only about senior citizens. It was about everyone, and it was mostly about future generations. And if we look at future generations, I think for the court and what I understood from the reasoning is that this is exactly where we come to it, that it's not someone who we don't, I mean, obviously it's someone who we don't know, it's future generations, but what we do know at this point of time is that there will be adverse effect on future generations. This has been proven scientifically. And what we also know is that the future generations are not represented, because they're not politically represented. So someone has to also stand for them. And I think the court then used this case to give this broader perspective and protection, including also future generations. And I find this to be a sort of a key factor. And if you look at the judgment, you can see how much the court has relied on it. Finally, also in light of time, just some final remarks on implications of this so far. Obviously, it's just been a couple of months, so it remains to be seen. But what I would say the implications would be is, as I mentioned, this is the first step in expanding climate change litigation. I think there's more to come. It is likely to affect standing in domestic rights litigation. Obviously, many states do not have standing for associations. This is something now that it will have to be extended. If it's not extended, then these associations will go directly to Strasbourg, which will bring the Strasbourg court in a difficult position, because if you don't exhaust domestic remedies because you don't have them, then obviously that you should be exempted from that application. At the same time, the court has a subsidiary role, so that is a difficulty. Obviously, more collective action. It's now NGOs that will litigate, so that you may think of that, whatever. Yeah, I don't know whether that's a good development, but that is what it seems to be coming. It is likely to unblock domestic legislation. We have seen national cases where the national courts were unable to decide because they've said the Strasbourg court has not said yet anything about Article 8 connection with climate change. And now it has. And finally, national laws in many states will have to be adjusted to accommodate this perfectly on time to accommodate this judgment. Thank you for your attention.
Thank you, Šejla. This is definitely a very interesting presentation as well. I have extended by 5 minutes, just not by my fully consciousness, because I was just taken, away by the case you were presenting. You have yourself addressed the question of the case raised different reactions, and that one of the reactions came from our next panelist. The beauty of CEENJ is that we, as you can see, combine here not just legal philosophers and legal theorists, but also other disciplines, other scholars. Myself, I'm also a resident alien and host alien. I don't know if there is that kind of category, Konstantinos. But we also bring here practitioners. And in light of the previous presentation, I'm very happy that we can, not just in light of that, but as a link to the previous one, I'm happy that I can announce Milica Novaković, whom I know from her early students' days, and who, to my big pleasure and honor, was also a member of the registry of the European Court of Human Rights. And so we have not just academics, but also practitioners, and we know that practitioners and academics do not always understand each other. So although Milica will give us at the moment a presentation on another aspect of justice, formal justice, but just to show as well that the formal justice can have different shades as well. Milica will speak and give a presentation on right of access to court, a brief history of an unwritten right. But I'm also sure that Milica will engage herself in this discussion regarding other topics raised at the panel. So, Milica, you will wait for me now to rehearse again my...
Thank you very much. Good afternoon. Before I start my presentation, I would like to thank Professor Hasanbegović, who invited me to take part in the conference, and to the committee of CEENJ, who accepted actually my application. As Professor Marinković said, I'm not an academic. At the moment, I'm on the second year of my PhD studies, and this is a very rare opportunity for myself to publicly examine and test my own thoughts, which otherwise probably I wouldn't share except in my student commitments. As Professor Marinković said, the topic of my presentation is right to access to court. I will briefly go through the case law of the European Court of Human Rights with regard to this procedural guarantee, given that, as I assume many of you know, the right to access to court is not regulated within the Convention, European Convention on Human Rights. Otherwise, it's a very, very broad topic, but I decided to narrow it down to the context of the European Convention. Given that it's not included explicitly into the Convention, this issue of the access to court appeared very early, actually almost 50 years ago, before the European Court through one case, namely the case Golder versus United Kingdom. I apologize, I'll switch to the slide. Very briefly about the facts of the case. The applicant in this case was a prisoner. He was serving his prison sentence, and at some point there was a fight in the prison, and according to some of the prison guardian statements, he was involved in the fight and he even hurted him. Later on, the prison guardian changed his statement, and it turned out actually that our applicant in this case was not present and did not participate in the fight, and that actually he was in the TV hall at the time. He wanted to institute proceedings, libel proceedings against the prison guardian, but given the very restrictive approach towards basically the civil rights of the prisoners at the time in UK, he was prevented because actually he was not allowed by the, at the time, State Secretary of Interior. Afterwards, he came before the European Court, claiming that actually he had the right to access the court in the sense to institute the proceedings. And that question was examined by the court. This case is important because in very, very broad interpretation of the statute of the Council of Europe, then the convention, the meaning and the purpose of Article 6, the court concluded that even though the right to access to court is not explicitly included as a separate guarantee into the right to a fair trial, it is implicit to the right to a fair trial because it wouldn't make any sense to basically to guarantee all the guarantees, all the sets of guarantees, all the metrics of the right to a fair trial without actually having the possibility or the opportunity to commence the proceedings. And it is important, and I make here a difference between Golder and other cases, because in this case, the court only referred to the right to access to court as a right to institute the proceedings. And the only thing, actually, the only interest that the applicant in this case had was to institute the proceedings. That is also an issue which was argued and commented and opposed by the government of the United Kingdom and so on. But still, the court established that it's imminent or imminent to the, to the implicit in the right to access to right to a fair trial to commence the proceedings. The court later on, in many different cases, which also concerned only the fact of instituting proceedings, confirmed this aspect and also confirmed that this is a guarantee or this is a right which should not be overburdened by excessive formalism, and it is a right which is guaranteed basically to every person, even to the persons with certain physical or other disadvantages. I suppose that it's also an issue which is of a concern for the applicants in the case which concerned climate changes, but we will come later to that. Very soon afterwards, another aspect of right to access to court appeared before the court, and that is not only a right to commence the proceedings in the context of a right to access, but also a right to conduct the proceedings in the context of the right to access to court. Namely, in the case Erie versus Ireland, Joanna Erie asked actually for domestically, asked for assistance in order to represent herself or eventually to have a court representation by professionals, by attorneys, in the court separation proceedings which she sought against her husband. Her husband had a court representative, she did not, and she could not even afford herself a court representation, nor she could represent herself. So she asked for a free legal aid. At the time, the free legal aid was not regulated by the Irish legislation, and that was basically the only means that she possibly could have in order to have proper representation. When her case, because she was dismissed that right and she was not recognized such a right before the domestic courts, when she came to the European Court, yet again, this application was examined in the context of the access to court. And the court basically did several issues here. In the first place, it recognized that the access to court is not only the right to commence the proceedings, but it is expanded throughout the entire process, in the entire conduct of the proceedings. And basically, it is applicable and it is guaranteed throughout all the court instances and until the final judgment is reached. But what is even more important is that here the ECHR gave us reference to the effectiveness of the access to court. If not effective, the right to access to court is empty, basically. So it must be effective. And how it is the right to access to court effective? It is when basically domestically you have different instruments available to have proper court representation, but also to have your case examined. And among the issues which it discussed, it also emphasized that the right to free legal aid is one of those instruments which should be available to at least certain categories of the parties to the proceedings in order for them to have a proper and effective access to court. yet again, the court emphasized that this right should not be overburdened with excessive formalism, and that, as I said, it does not only concern the right to institute proceedings, but also to have your case examined with the final resolution, whatever the resolution is, but at least to have the final judgment. Here, the court expanded very much the right to access to court, bringing it almost equal to the right to a fair trial itself. And in the entire body of case law later on, it confirmed basically that in various ways, which are basically various procedural steps, which both the parties can undertake, and as well as the courts can undertake in those ways that the right to have access to court can be basically exercised. Turning to the European Union, I decided to just to give you a brief reference to the European Union legislation because, as I said, the European Convention on Human Rights does not regulate a right to access to court directly or explicitly, and it was quite a challenge for the judges in the Boulder case. I expected, I mean, not me personally that much, but of course the scholars and so on, that there would be certain modus operandi in which the Charter of Fundamental Rights would, in a way, include the right to access to court, because it is a sort of, I would say, younger brother, I call it, of the European Convention on Human Rights. And throughout its jurisprudence, the Court of Justice of the European Union very much relied on the jurisprudence of the European Court of Human Rights. And after all, the Charter eventually contains the reference to the jurisprudence, where it explicitly says that basically the standards of the European Court and European Convention are the minimum standards which are being adopted by the European Union in the Charter. However, even though the Article 47, which refers both to the right to effective legal remedy and to a fair trial, covers the right to a fair trial, it yet again does not cover the right to access to court in very explicit way. But in the third paragraph, it does guarantee the right to free legal aid. On one hand, that is a step further, and that is, how to say, a very progressive step, given that the right to free legal aid provision of the free legal aid is very, very demanding. And as we yesterday heard from our Turkish colleagues, it may be, while it is a very useful instrument, it may be, on the other hand, very challenging to provide. Yet we have it included, and I have to say that I did not consult into many details the practice of the Court of Justice of the European Union, but we shall see how direct guarantee and operationalization of the free legal aid right works in the practice of the European Union. And finally, given that, by the way, I didn't mention, my topic actually is my presentation. Yeah, sorry. My presentation, by the way, is part of my research, which I did for my PhD studies. So I also included into my research the Constitution and the constitutional practice of our Constitutional Court. This is very particular and special study, I would say case study, because in the first place, Article 32 of the Constitution of the Republic of Serbia is set, first of all, correspondent to Article 6 of the European Convention, which concerns the right to a fair trial. But it is set in a much broader way, because, for example, it does not require for a dispute to exist. So basically, the right to a fair trial in Serbia is guaranteed to basically all the proceedings which are regulated. However, our constitution is a bit, at least in principle, progressive, because, for example, it did not limit the right to a court interpreter and interpreter for deaf and blind people solely, for example, to criminal proceedings, but it actually extended it to basically every physical person in every sort of proceedings which is possible to conduct in Serbia. How that in practice works, I'm not so sure. It's very demanding, but at least we have it as a right guaranteed. And in this way, also the access to court to many categories and virtually to many more people is not limited. The second way in which, even though the Article 32 does not regulate the right to access to court, this guarantee is present in our constitution is through the provisions which concern the free legal aid. However, even this institute is limited in two aspects, I would say. The first is in terms of providers of the free legal aid, because free legal aid in Serbia may be provided solely by the attorneys and by the employees of the offices of the local self-government, which means that basically formally NGOs and other sorts of associations cannot provide directly the free legal aid unless they have attorneys who basically de facto represent them and represent their parties. I went through a serious body of the case law of the Constitutional Court, and our Constitutional Court, at least this reconstituted Constitutional Court, at the beginning very much struggled with terminology and definition and the proper application of the concept of the access to court, even though I have to say effectively it's recognized the violations. In the first 5 years, I would say, of the jurisprudence, there was, I wouldn't say a mess, but definitely a disagreement between what's being expected from the Constitutional Court and its own practice. There are many cases in which, for example, the Constitutional Court basically only translated the definitions of the European Court in terms of what constitutes the right to access to court, but the terminology which was being used and the concept as such, as a product, was very much confusing. But what is good is that actually the applicants or the claimants in these cases at least got their satisfaction in terms of recognition of their rights being violated. Then the right to access to court is recognized in all kinds of proceedings: criminal, civil, misdemeanor, enforcement, and administrative. Also, for the Constitutional Court, with no exception, excessive formalism is not acceptable. Then the third conclusion which I made on the basis of our case law is that most of the cases concern either civil or administrative proceedings, but there is a certain group of cases which are very indicative because in not only a few of them, the applicants complained before the Constitutional Court that decisions of the state bodies and the bodies of the local self-government did not contain proper instruction on the use of legal remedies. So basically, they were basically deprived of their right to access to court in terms of instruction, which they were supposed to be given. So they would waste a lot of time and a lot of money in basically finding which is the proper body which they should refer to in the second instance, or before they would go to the administrative court, or they would wait basically for the administrative silence to, let's say, appear, and then to go to the administrative court, which is absolutely unacceptable. Another interesting feature of the case law of our Constitutional Court in terms of right to access to court is that, of course, normally and naturally, domestic courts deal with different kinds of, I would say, challenges, and not all appear before the European Court of Human Rights. But in many cases, our Constitutional Court determined that the right to access to court was violated by arbitrary interpretation of both material and procedural sphere. In these cases, there was no evident abuse as it was in the administrative cases, but maybe, I mean, if you see and assess the entire setting and the entire factual background, you may see that actually the right to access to court is violated because simply people, actually those with powers, were abusing their positions. And the final conclusion which I made about our Constitutional Court jurisprudence. I think I said everything. Yes. So in this my very modest examination of the right to access to court, I think that we may conclude that basically there is a right to access to court in a narrow sense, which concerns only the right to institute the proceedings, whereas there is always there is also possibility to consider right to access to court in a broader sense, which also encompasses the right to have the right to access to court in terms of having your case resolved and having your judgment reached, or any sort of other decision which is possible. Also, the right to access to court is not an absolute right. It may be limited, but it's not limited for any other purpose but for basically judicial effectiveness. And it may be limited by legal principles such as res judicata. It may be limited in terms of various deadlines which contribute to the effectiveness of the proceedings. And finally, which was basically the main question which I posed to myself, whether the right to access to court may be regulated explicitly, because it was not as such included into the European Convention. I think it could be, but it would take a lot of linguistic efforts to find the proper definition. But as long as the domestic courts do not arbitrarily interpret the legislation nor abuse, which I noticed in the certain body of the case law of our Constitutional Court, the access to court can be effectively practiced. Thank you.
Thank you very much, Milica, for your also interesting presentation, and in particular for addressing the Constitutional Court practice. That is something which we miss, which we lack. I especially like the question of right to Constitutional Court itself, and in particular in electoral law disputes, but to other conferences. Now I give the space and the floor to all of you. I see Professor Tatiana.
Be brief as much as possible. Mr. Bukovič and Ms. Imamović, the question is for both of you. Can you imagine that a European Court of Justice or any high court says, okay, I act in loco parente for future generations which are not yet born. And my first concern is that the future generations are born. To that end, a fertile woman should have 2.2 or 2.5 children. It used to be 2.2, but for various. What is the problem in society? It is obviously not what the European Commission stated a few months ago, that the solution of depopulation is a greater access of women to the labor market. The solution, the only possible solution of the problem of depopulation is that men assume seriously their parental duties, not rights, duties. And to that end, what we should do is to put a heavier burden on men rather than on giving privileges like the, what is that? What we are talking about? Bukovič. Yeah, affirmative action. I learned that during the time of Nixon. That was a great fun. Okay, what would you say on that kind of reasoning? Because what I think we are, I don't, look, you all know that much better than I do. Okay. This is the problems of legal philosophy to a great extent boil down to the problem of two perspectives identified by John Rawls and by many other thinkers before and after him. One is utilitarian, axiological. This is the perspective of a legislator. The other one is deontological, which is the perspective of a judge, right? Now, Roosevelt was strong enough to force his judges to say, okay, I'm going to appoint 3 or 4 additional judges. unless you stop perpetuating your point of view, which is not just philosophical unilateral. It is excessively liberal. It is undemocratic. It prevents us from making the New Deal work, right? So I'm going to stop that kind of stuff. Now, why can't we do something like that? First of all, in the jurisprudential thinking, my very learned colleague, Miomir Matulović, invited the unfortunately prematurely deceased Marko Petrak to the Faculty of Law in Rijeka. And he said, of course I'm coming, provided you set up for me a chair in objective law. Because you have transformed the chair of this latent story into human rights. Was it enough? Can you imagine that scenario?
We'll pick up a couple of questions. Bojana has also raised hand, and Isabella.
Thank you.
Thank you. Oh, no.
No, Isabel, you can go. You can go first.
Okay. Thank you so much. A question for Martin. I am perplexed about the link between the communitarianism and the argument of historical inequalities. I think that this is my question. Don't you think that the argument is more, I would say, universal? It's an argument that you can use also from other perspectives, not necessarily from a communitarian point of view. This is my question. And from this point of view, obviously, I understand the utilitarian argument against the individual rights, but the point is the temporary status of the measure. It's I will defend just this position. And for Milica, I have just a curiosity. If I didn't understand badly, you say that the free legal aid is prohibited in Serbia, and I was curious about these prohibitions. Prohibition is impossible to stand in court for NGOs and so on, because if I am an individual and I look for legal aid in a law firm that is supported by an NGO, why is that a case of in which it is prohibited? Is something that you can do?
Thank you, Isabel. We'll pick up some more. We heard you well. We will pick up a few more questions.
Thank you, and thanks to all the presenters. I really enjoyed the 3 presentations, and I was very much looking forward to this session. For Šejla, I couldn't agree more with everything that you said, and I share your understanding of the judgment and the assessment that you gave. I also think that the court made some very important pronouncements. All of them you mentioned, the link with human rights, between human rights and climate change. We should not forget that this is the first ever judgment of an international court in that regard. We are waiting for some others, although in advisory proceedings, so we have something before the ICJ at the moment, before the Inter-American Court of Human Rights, and I'm sure that this judgment will definitely influence their pronouncements as well. The fact that the court interpreted positive obligations of states with relation to Articles 2 and 8 in line with the Paris Agreement and the duty to mitigate climate change harm and to adapt to climate change harm. I think that it's a huge step forward. The fact that the principle of common but differentiated responsibilities as one of the basic principles of international environmental law was not used by the court as a shield not to give certain answers to the questions that we were waiting for. And the fact that you mentioned rights of future generations. The court is not that clear upon that, and you discussed that issue with regard to the issue of standing. But what I wanted maybe to hear your perspective is whether this can also be used in the context of positive obligations. Does the court also maybe indirectly sends the message that states, while making decisions in their decision-making processes, should also have to take into account the rights of future generations and the way that climate change is going to influence them? And another issue that you were talking about, the standing of environmental NGOs. I'm sure that you took a look at the August 28 answer of the Swiss Federal Council and their arguments in the course of this process of implementing the judgment, because that is also something that I wanted to hear your opinion about. So what are we to expect? Because the Swiss government seems to have contested this interpretation of standing of environmental NGOs. And what do you think, how this will influence the process of implementing the decision, which is yet to occur? It's only started, but the signals that the Swiss government is sending are directed actually at the issue that you were dealing with. Thank you. Sorry, if I may, for Milica, just one question. You said that you analyzed the case law of the Constitutional Court. I was just wondering, how would you assess the court's taking into account of Strasbourg standards? To what extent does it refer to Article 6 cases before the European Court of Human Rights? In what manner? Generally, how do you see that? Do you see an improvement in that regard that could happen, especially if we take into account Article 18 of our Constitution and the relevance of international standards for our bodies? Thank you.
Thank you, Bojana. Now, Gülriz, Konstantinos, Claudio, and then Igor.
Yeah. Firstly, me. Yeah. Thank you. First of all, I would like to ask the affirmative action. I think the first question regarding this point, why we need affirmative action. For this reason, I think we should start from a feminist legal theory or directly connected with the thinkers like Martha Nussbaum or Iris Marion Young. Okay, we should move forward this, and then what we can say, the other theories, what can they say? We should consider this later. Secondly, I would like to ask connected with access to justice. First of all, I would like to ask that why the court regard access to justice in the wider meaning. There are the doctrine connected with this huge doctrine. What is the meaning of access to justice? Secondly, we know that 2015 CEDAW General Recommendation 33 about women's access to justice. It includes 6 principles. One of them, accessibility. Why court do not regard CEDAW General Recommendation 32 connected with access to justice to meaning? In the past, it did it. We know the Opus case, the court regard what is the discrimination meaning connected with CEDAW. We know the examples. And then from the 2015 until this time, there are many discussions about access to justice, especially women's access to justice. Why the court does not regard these discussions? Thank you.
Just one brief remark and one question, just to connect theory and practice. We should note that Article 6 does not cover as cases of civil character, immigration, asylum, and if I'm not mistaken, citizenship. This means that in these cases, jurisprudence can be inconsistent because usually consistency is guaranteed by the Supreme Court of the jurisdiction. And we could wonder also if it is sovereignty we're talking about when national lawyers handling, for example, asylum cases, always use the precedents from the ECHR, Article 3 or Article 2, and do not have enough national jurisprudence of Supreme Courts to invoke for those cases. So this would be a nice question to wonder if this is compatible with universality of hospitality or such notions. And one question to Šejla and Milica. Would Article 6, that is environmental cases as cases of civil character, would be a possibility to ground applications before the ECHR for individual persons, since in most legislations, in Greece, for example, protection of the environment and adequate living conditions are explicitly stated in the Constitution as a right. So would it be a ground for an individual to go, not an association, to go and say the national courts do not provide any protection against climate change and please try my case? Thank you.
Thank you, Costa. Thank you very much. I have a question for Šejla, and in the light of your knowledge of the subject matter and curiosity, much more than a question about your very good presentation, for which I'm thankful. So how are we supposed, about the future generations, how are we supposed to be held accountable if, notwithstanding our good intentions toward future generation, we screw up completely? Because we can affect the behalf and also the very existence of future generation, but once the effects of our action will spread, future generation cannot do nothing towards us because simply we are dead. So how can we, are we supposed to be held accountable for this? And if this argument appears in any way in the reasoning of the court or of the literature that you know. Thank you very much.
Yes, it would be also interesting to take into account the argument of future generations when states take debts, when they indebt themselves, because we do it actually at the expense of those to come.
Yes, but here we are people.
Yes. Okay, sorry. I'm just saying there is various expansions. Now, Igor.
Thank you. A brief remark and more in addition to some previous questions. It is related to Martin's presentation. Thank you for a very interesting presentation. I have some dilemmas regarding your choice of different theories and different theorists regarding the problem of affirmative action. First, about utilitarian argument, it can go both ways, for but also against affirmative action, perhaps even more against affirmative action. Also, I do believe that John Rawls should be mentioned because his difference principle is very important in this context. So just a brief comment, and it is also already mentioned in some other questions. Thank you.
Thank you, Igor. And now we give the floor back to our panelists, maybe in the opposite order of their presentation.
Here's some. Well, probably this is more, well, I would be brief, I suppose. As for Isabel's question on the free legal aid in Serbia, The free legal aid is guaranteed under the Constitution, but the providers are actually the categories of the providers are limited in the sense that the free legal aid can be provided to certain categories recognized as such under the law on free legal aid only by the attorneys and by the lawyers employed in the government's, not the governments, I'm sorry, but the offices of the local self-government. As for the NGOs, formally, they do not have a right to provide and to appear before the courts as court representatives or before the administrative bodies of the parties. However, it is the practice developed here that those who are registered attorneys appear and they get paid through the projects and so on by the NGOs. So I hope that, I'm sorry, I hope that answers your question. As for the application of Article 18 of the Constitution, yes, the Article 18, which refers to the international agreements and the standards adopted on the international level, is applicable and the Constitutional Court applies it. I found several, not many, but several decisions where the court explicitly said that it applies and in the interpretation of the Constitution and the rights, the standards which are adopted internationally in the sphere of human rights. What I would add here is that I think it's Article 80 something, I think, which separately explicitly regulates the right to access to court in administrative proceedings. That's one of those peculiarities of our Constitution, which I omitted to mention. As for the Strasbourg standards, it literally copies without any examination, but it employs those standards even in some cases which at least to my knowledge did not appear before the ECHR, because in several cases our Constitutional Court even determined that the quality of the legislation, of domestic legislation was such that it deprived the applicants of their right to access to court. As for the application of the CEDAW Convention and the comments, I have to say that I'm not familiar that much with those cases. However, given certain other body of the case law that I'm familiar with, the CEDAW Convention is included very often into the jurisprudence of the court, but I have to say that I'm not familiar that much. Maybe in the body of the case law, which concerns the Istanbul Convention and the violence against women, maybe in those cases, but for the time being, I just cannot remember any. As for the hospitality and access to court, if I remember very well your question, the signatories to the European Convention have margin of appreciation, which is applicable in their exercise of the rights, but also they are not, how to say, they are not limited in how they guarantee domestically right to access the court, because we can see on the case and the example of Serbia that basically the right to access to court is not that much limited in Serbia. So it basically depends on the decision of the domestic legislators on how basically the right to access to court would be legislated. And as for the individual applications, if that was your question as well, that's one of the issues which appeared in those environmental cases, not environmental, but the climate-related cases. I disagree with the court's approach. There is absolutely no reason, and I would dare to be this direct, no sound mind would deprive any individual of a right to access to court if the person is affected by climate change. So that's my answer.
So with regard to the first question, I think I might need to ask you to sort of tell me again what exactly
You said that the court in the climate case,
yes,
acted in loco parente. I translated it to the term which you obviously know.
Yeah.
Taking care of future generations which are not yet here.
Mm-hmm.
So I'm saying isn't that so that in the case that was presented by Mr. Bukovič, in that type of cases of affirmative action, right? While we are discussing the equality of men and women, which is a social, economic, and I would say natural right, the way the climate is a right towards the healthy environment, right? The world. We cannot treat such cases as if they were plain civil and political rights, like the access to court. They're completely different. Because whenever a high court, constitutional court, Supreme Court, acts in such cases, its decisions have a redistributive function. They change, in your cases, what you are discussing, they change the world we live in, okay? They change the, it is even much more important than the socioeconomic cases, yeah? This is the most important case you are discussing. So I'm trying to say, if the court came to senses and realized that the court has to take the position, loco parente, acting on behalf of the generations that are not yet here, isn't the same principle valid in the case of affirmative action that tries to make a balance between the position of men and women as parents? And I deliberately mentioned the recent resolution of the European Commission, which said, we are fully aware of the problem of depopulation. There are some economists in the America, libertarian, by the way, I forgot his name, I quote him often, that this is the most important problem today. You may say that it is not relevant. I'm not advocating repopulation. I'm advocating social state, the social state, because the social state is based on the principle pay as you go. And it can exist only as long as there is a reproduction of the people. Okay, if you don't have children, no one is going to pay your rent, no one is going to pay your health insurance when you need it. Okay, so I'm not acting on behalf of population. I'm talking about the social state. Now, if the court in such an extremely important case had the guts to say, I am acting loco parente for the future generations, should not the court, which is taking the powers which I do not agree with, of overriding legislature, but in Europe there is no legislature, so they can do whatever they do. The problem with the court is that they, first of all, they put in disbalance the relationship between the executive and the legislature, which does not exist, whatever it is in Europe, European Commission, Parliament, Council, but and at the same time, they usurp powers of the nation state. Yeah, I would dismiss the case of the people of Switzerland. I would say, look, change your constitution. Look at the Croatian constitution. They have the right to health environment, written in for 35 years. Okay.
Yeah.
You see what I'm saying?
Yeah.
So why not look apparently at socioeconomic rights if you do it? I disapprove. I think it's the matter for legislature. But why not look at loco parente and say, these are trivial things. That guy is obviously a single father who wants to put his kids into a kindergarten. We cannot look at his sole case. The problem we are facing is that men systematically have been avoiding everyone, including the highly developed Western countries, their parental duties, right? Just imagine of the number of people who are divorced and who do not avoid to pay their aliments. Just imagine of the number of people who never wash dishes at home, not to speak of the other things that they talk to children, right? You see, Stefano told me yesterday that he has 3 kids. You have 3 phases in your life. The second phase of your life is not your career. It is your children, if you are a responsible father. So when the court is doing that, it is standing loco parente, why not make that final move? That is my argument, right?
Yeah.
Why do we never talk about the social state? That the social state functions on the principle pay as you go. When I talk to my friends and colleagues, economists in Croatia, they don't understand. A friend of mine, an economist who has been working all her life in the Bureau of Statistics, says, I've been paying for my health insurance all of my life. And now I have to wait for 6 months for a checkup. And my answer was, well, why? Because you have only one child, just as I do. But you are paying for your parents. She cannot understand the argument. You see, and that is the problem all over Europe. They simply don't understand the argument that our world is good in Europe because of the socialists. It is by far the best institution that has ever been created in the history of mankind. Free medical, decent pensions, free education. Okay? And we take for granted that it can function without kids. I don't care. I mean, if I was really fond of kids, I would have 5, right? I didn't. I'm talking about a legal problem, not about my personal preferences. You understand it? And that is why I'm asking you, can you imagine that the court, which was so conscientious as he was, and I would be delighted, just as you are, by that decision, yeah? Can you imagine that it is conscientious the same way when it comes to the social state? Socioeconomic rights, especially equal treatment of men and women, that will really make a difference. Because look, when the European Commission wants to repopulate Europe and says that the way to do it by a greater access of women to labor market, only an idiot can say that. You must be. You understand me? They're directly opposite results. If you want to make population, you must make parents, male, responsible. And that requires a completely different social policy. I can't even think of it. But it does require a completely different economic, social policy, everything. Okay, sorry.
Okay.
But you asked me for the explanation. And I don't find that people, you see, the elderly gentleman, he does understand what I'm talking about. He's a parent, the grandpa, whatever, and he knows how the world works. The younger people simply think it comes from the start. I don't know, from, you see?
Yeah.
Just a single sentence. I think what you're talking about, of course, would not be plausible, but that's probably due to the legal system's focus on individual rights. And everyone would say, well, you can't infringe on the individual's right of choice whether to be a parent and what sort of parent to be.
I'm talking about the interests of financial capitalism. Yes. Okay? It is in the interest of the financial capitalism that in the West, families do not function. Why? Because our kids are expensive. My neighbors from Nepal, your neighbors from Uzbekistan, and so on, are cheap. When they are no longer needed, we'll throw them out. And if we become socially conscious, as the Germans have become, well, we will be in a deep trouble. Look at Germany. Okay? Because they have given all their social rights to the foreigners, and that now they don't know what to do. You see, and the problem is really, do you really believe in objective law? The teaching chair I established 45 years ago was changed into no longer theory of law and state. It is just with the title. No one does that except me. I'm 77, and my junior colleagues do legal human rights.
Yeah.
Human rights. And they, if I told them, they would be deeply offended if I told them you are inadvertently a servant of financial capital. They don't have, I don't believe in conspiracy theories, but they will be stupid if they didn't know, give a lot of money, say, to the Greens in Croatia. They would be extremely stupid, and as far as I know, financial capitalism is not stupid. It may be greedy, but not stupid. Did I make myself clear? I'm just asking you, can you imagine? Because this is such a bold decision. It is such a good decision. I'm glad that I learned it from you. I'm glad that you made the comment. I enjoyed it. But just, can you see it as a turning point? This is my question. And this is why I asked that question. You, and I can always talk to him as the author of this, but you know the most important case. Paternalistic. Look, the argument is paternalistic.
Okay, I distributed the mics here. So
sorry.
Thank you.
No, but she wanted me to explain what I meant. So I did explain. I didn't have to explain to the gentleman over there. I understood immediately what I was talking, right?
You just started the new program. So something special with these. Okay, thank you. Šejla.
Yeah, so I think, yeah, can I imagine that the European Court of Human Rights would now go and make such decisions based on, yeah. I think, yeah, I think the court has made significant advancements towards more equality between men and women. It's one of the underlying values of the Council of Europe and the court case law. But in that specific context that you are describing about children and so on, I think that's difficult because of what was mentioned before, because it involves different individual rights, because I've spoken about the rights of future generations, but there are also rights of people who are currently living. And so when we have a conflict between different rights, or a certain balance needs to be reached, then decisions become more complex. So yeah, I'm not sure that I can give any.
I don't want to bother you. I mean, there are so many questions.
Yeah, I think they can probably give a better answer, and I've seen a lot of nodding and from the colleague who has written the paper on affirmative action. So I'm sure they'll have more, clarifications for you in that regard. Boyan, I think, was the next one. I think with two questions, if I have them correctly noted. So the first question was regarding the use of future generations in connection with positive obligations, right? Whether it could also be used in that context in development of a positive, or has it been used? Will it be used? I think from when I look at the judgment, it is indeed true that the majority does not really refer when the positive obligations are discussed or analyzed to the aspect of future generations. However, in the dissenting opinion, this is taken in as being elements in the analysis or in the reasoning as to why positive obligation was established. So I imagine that it is something that was also in the mind of the court, but the court for some reason omitted to focus on that element when talking about the positive obligations. I think I certainly see space for it for when developing the doctrine of positive obligations in the context of climate change, because ultimately as I said also in my presentation, I think the underlying motivation for the court is indeed this intergenerational equity and future generations. And if that means developing further and stretching the positive obligations doctrine in the case law that they have, that they could use it and they could do it in the future. So the and in fact also in the judgment when this was developed, there was mention of disproportionate burden of future generations. So it did sort of play a role still in the reasoning of the court. And then the second question was about the Swiss, right? The Swiss government and the refusing to implement this judgment, and how do I see the process of implementation? Yeah, I think this is obviously very, very difficult. It's the most we always speak about. Talked about this before. We always speak about the court and the judgments, and up until the moment that they're rendered, we discuss them, but then the execution is the real challenge. So the court has identified gaps in the legislation of Switzerland in terms of targets and so on. So essentially it would require amendments of the legislation, but the government has already tried that, but then it was refused in the referendum. And that was actually why the problem arose. So that brings then the question of the whole constitutional setup of Switzerland and how to deal with that if we have laws that have been refused in the referendum, how to change that. At the same time, we have a judgment that is legally binding and that the state has to comply with. Switzerland, but also looking more broadly, many argue that it has sort of erga omnes effect, or that it should be seen in that way. So while there is this initial, I think, a little bit of a also Switzerland of all countries to get this kind of judgment, there is a little bit of like, no, we're not complying, we're doing so much already. What about other states? There is always this problem. But ultimately, my expectation is that, I mean, the process will go as with anything. There will council minister, there will be some peer pressure and so on. It's very important to execute the judgment also as a message to other states. I imagine that the judgment will be executed, but politically, how long still it will take and in what way, that remains to be seen. I cannot predict that. Okay. Moving on, what was the question? Article 6 on, yeah, you already sort of answered it, whether that would be a possibility for individual persons, because normally they would not have legal standing, right? That was your question. Normally in climate change, they would not, and so what if they have it at home? Yeah, that's very interesting, because we have seen that before in ECHR law, where, you know, the court has said, for example, in the cases where I think again it reminds me of same-sex marriages and things, and then discrimination in that regard, and then where the court has said, well, this right does not exist under the ECHR law. However, although this is a substantive discussion, however, if the member state provides for such a right, then there can be no, let's say, no discrimination in that. And so I think connections could be made, but I don't think that just because it is at the national level that it directly means that it exists at the ECHR level. That's just my preliminary thoughts. I'm not sure, to be honest. And then because it's such a, also this judgment is so complex on this matter of Article 6, in terms of what it means for the future, but the court has been so clear in putting this high threshold for individuals seeking justice. I don't think the court wants individuals. Collective actions, okay, but individual claims based on climate change, I think the court is not prepared to have that in Strasbourg. And then the question here was, what if we don't fulfill our obligations and accountability, right? That was your question. How can we be accountable towards future generations? The only thing I can say is that I guess we cannot really be accountable. And I think that is why the court is the European Court of Human Rights in this specific case, but also national courts. Think of Urgenda in the Netherlands, but also some other states where the national courts have been active and have been deciding. I think that's why national courts are trying to take a stance and provide that protection for, or a representation in any event for those future generations who not only cannot represent themselves right now, but also will not be able to, we cannot go back. If the temperature keeps rising, if the greenhouse gas emissions continue, we cannot, well, we could try to reverse, but it will only get more expensive, more complicated, more difficult as the time goes on. So in that sense, and as you say, we will no longer be here. So in that sense, I think it's a kind of a priori accountability that is that courts now and some legislative bodies are trying to establish at this point of time. Yeah, I think I've addressed all questions. Have I forgotten anyone? I don't think so.
Yes, so for me, thank you for your questions. And first of all, I would like to tell that I didn't deal with the feminist theories because I think, or in my view, I deal with the affirmative actions like that generates new inequalities, and it's not only binded with the gender, it can be binded with the ethnics or other discriminatory grounds. So I just want to point out that it generates new inequality in accordance to working, that there are that two views of the equality, like treating like equal and equally treating. And that's why I didn't like deal with the raw story of justice is fairness. I know that we can apply that thoughts on some interpretation. How can be affirmative action defined, or how can we deal with the affirmative action like a positive way? But I just wanted to point out that the new type of inequality, and that's I think it's important message of my presentation. And also like as I mentioned, two theories like communitarianism and utilitarianism. Yes, in communitarianism, I just want to say that the principle of justice is in each sphere different, like this get different meaning there. And affirmative action can, in one sphere, can be thought like it's in universal principle, like with the utilitarianism thoughts, as I mentioned. So yeah, that was only to my theories, but the main message was just point out the working theory. And I don't want to jump into some thoughts about the social impact. I just want to point out that that we cannot just have the condition for the distinction based on the gender, based on some nationality, but we need to look at this problem more widely and to consequence to each individual and his rights and his possibilities to reach some position, some abilities, something like that. So that's my answer for your whole questions, I think. And thank you.
Thank you, Martin. I see that we have breached by only half an hour our time slot, but I heard your need to speak, my dear people. So who cares about the institutions and the protocols? So if there is any more juices left in you, we will start the final 8th session at 5:10. See you in 40 minutes.